right, so to get started again, so we've described the basic problem. How does this come up? It comes up again because you have the failure to agree on FRAND licensing terms between the parties. And so what the Chinese firms have done, and I'll start by noting this isn't the first time that this type of action has been brought, but they have gone to the domestic court in China, like the Wuhan Intermediate People's Court or what have you, and they have filed a lawsuit to prevent the company from enforcing its patent in China against them and requesting the court to determine what the fair royalty should be for the FRAND license. But they are not simply requesting a determination about a license for China. They are seeking an order that will determine a global licensing royalty. Because at the end of the day, what they need is to resolve this dispute so that they can use the technology wherever they need to use it around the world. And really the kind of idea of the FRAND license is that it should be a global, non-discriminatory license. But so they go to court in China and they request the Chinese court to resolve the dispute. Nothing unusual about that. But then they request the court to grant what's called an anti-suit injunction. And in the anti-suit injunction, they ask the court to tell the patent holder that not only may you not enforce your patent in China, but we want you to issue an order telling the company, the patent owner, that they may not enforce their patent in any court in any country of the world pending resolution of the dispute. So what they're seeking is called an anti-suit injunction. Not only must you stop in China, but you may not try to enforce, so let's assume you have a German technical standard patent. It says you may not sue us in Germany, or if you have already sued us in Germany, you must request the German court to stop the proceeding pending the resolution of our dispute. So we want the Chinese court to establish itself as the court that will resolve this dispute around the world, and we want you, the patent holder, not to enforce your patent in any other country until this is settled. And you have had then you had a number of Chinese courts which issued such anti-suit injunctions, telling the patent holder, not only are you blocked in China, but you have to stop this litigation everywhere else, and if you do not do that, you will be subject to a fine of 1 million RMB every day, right? A daily 1 million RMB fine, if you continue your litigation elsewhere. Now, to be clear, the Chinese courts are not directing an order at a foreign court. They're not saying to the German court, we hereby issue you an order, you have to stop your proceeding. They're issuing an order to the private company, the patent owner, saying, you have to stop. You have to suspend your action pending the resolution, and if you don't, these are the consequences. Now, of course, I would add that, almost a parenthetical, of course, for any of us, a 1 million RMB a day fine sounds like a lot of money. It's more money than you make in a week. But for a big company that's doing a global business, I mean, you can't even necessarily say that 1 million RMB in US dollars, it's about $150,000. Most big companies can afford $150,000 a day without that much difficulty. It's not the end of the world, but that's the fine they're imposing. So this has made the European Union very unhappy. Now, why is the European Union unhappy? And again, I'll go back and say, you've had American courts in different types of cases have issued anti-suit injunctions. British courts have issued anti-suit injunctions under different circumstances. So the Chinese court's doing this, they didn't invent the anti-suit injunction. This is not the first time anti-suit injunctions have been issued, but what is the European Union argument then? Well, to start with, of course, after discussing with China, you have to have preliminary negotiations. They filed a dispute at the World Trade Organization saying that these anti-suit injunctions, what China is doing, is a violation of the TRIPS agreement. So there's various grounds, and I'll start. We wouldn't do this with a movie. I wouldn't tell you the end before the beginning, but in any case, the WTO panel, so this is the first instance, this is like the trial court. The WTO panel found against the European Union and in favor of China, although there is a small part of the decision against China. It just had to do with when the decisions were published, which kind of a separate thing, so we can put that aside. We're not worried about the when you publish the decision issue, right? So what was the European Union claiming, right? What was the European Union's argument under the TRIPS agreement? Now, let me divert us here for a second to the TRIPS agreement. So here's the TRIPS agreement. Now, this may seem a bit odd, but the main argument of the European Union actually focuses on this first sentence. Members shall give effect to the provisions of this agreement. Article 1.1, first sentence. So the European Union says China is not properly giving effect to the provisions of this agreement. And then you are combining that. I have to go a little ways in here, sorry. So then you have Article 28 of the TRIPS agreement. So you have apologies for the formatting, but So these are the rights a patent confers with the subject matter of a patent to prevent third parties from making, using, offering for sale. So one of the things the European Union is saying that by having these anti-suit injunctions, the patent owner isn't able to exercise these rights which are provided by the TRIPS agreement. It's also referring to Article 28.2, patent owners shall have the right to assign, transfer by succession the patent, and to conclude licensing contracts. So part of the EU's argument is that what China is doing is interfering with the right of the patent owner to conclude the licensing contracts. And it also relies it just FYI, if you're interested in compulsory licensing, there's the major provision dealing with that, Article 31. It does make a reference to Article 41.1 that you shall make available provisions to enforce intellectual property rights. So that's here in Article 41.1, and then it refers to Article 44, and Article 44 refers to the fact that courts should have the ability to grant injunctions to prevent infringement. So the EU invokes a variety of these provisions, but the main one it relies on is, if you go all the way back to that Article 1.1. Now, the panel decided the case. Well, one of the things the European Union said, and this doesn't necessarily rely on a specific one of those provisions, except with the general idea which is in there about having an independent judiciary or administrative body to decide the decisions. And I mention this not so that it's so important, but because the WTO panel decision devotes a lot of time to it. The Chinese lower courts all adopt the same reasoning in making the decision. After the first decision, which lays out a 4-factor test, which apparently derives from the Supreme Court of China, the lower courts all basically follow the same set of principles and factors in making their determination and arrive at basically the same result, including the amount of the fine. And part of the EU's argument is that, I'm just telling you the EU's argument, I'm not telling you whether you should support that or not. The EU's arguing this isn't really an independent judicial decision. This is a decision being made by a higher authority and being carried out by the lower courts. So we think that this is more in the nature of a government rule or edict rather than an independent judicial decision. And that's one of the arguments that the EU is making. And the panel is addressing that at great length. What each of the courts did and what each of the results is. I would further add that I think in each case, the net result of all of this is after the Chinese court decision, the parties, the private parties, concluded voluntary licenses between themselves. They all ended up reaching global licensing agreements after these decisions were rendered. So the panel looked at this and said, well, we don't really find a place in the TRIPS agreement where it specifically tells the Chinese courts or China that it cannot use this procedure called the anti-suit injunction. We don't find what we'll call the hook or the line of the TRIPS agreement that says you cannot do that. And the EU has argued that China isn't really implementing the agreement in good faith. And the panel says, well, that's not really our question, right? We don't really try to determine whether a government is acting in good faith or a bad faith. That's not so much of a WTO decision. If you want to make your case, you need to make it by finding a provision of the agreement that says whether or not you can do that. And it's a lengthy panel decision. If you're interested in WTO law and TRIPS agreement law, you may want to read it. I'm not such a big fan of the panel's decision in this case because I'm not saying how the decision should have come out, but I think they undervalued a certain aspect of the TRIPS agreement that they should have paid more attention to. And it's not because I think it's important with respect to anti-suit injunctions. For me, this isn't a big issue, but it comes up in other areas. I don't think they looked enough at this idea of independence of patents, which if you go all the way back to the beginning when I said there's certain basic principles of intellectual property law and patent law, and that basic principle says that a patent in one country is independent of the patent in all other countries. And so if you're really looking at this idea of independence and combine that with territoriality, that the patent owner has an independent right to enforce its patent in each jurisdiction. And it raises a serious question if one country says to another country, your courts can't enforce the patent in your jurisdiction because our court over here says you can't do it. Now, part of the answer to that is, but we're not telling the court. I was careful to tell you. The Chinese court isn't saying to the German court, stop. It's not issuing an order to the German court. It's issuing an order to a private company saying, you have to stop or you'll be penalized in China. But effectively, and this is what concerns the European Union, I don't think they made their legal case very well, is the effect it has systemically on whether a particular patent owner has a particular right to enforce its patent in a jurisdiction. And that for myself, if I were arguing the case, and I did argue a big case at the WTO based on this independence, so kind of a self-interest, on this independence contact, that I worry about this a bit from a systemic standpoint. This actually comes up a lot in pharmaceuticals and healthcare, and whether the patents are independent of each other Or for example, a big pharmaceutical company could say, well, because we have a patent here, we should also be able to enforce it there, and we should follow the same rules, and different countries can't adopt their own mechanism. Now, well, so let's say I'm hearing this case and say, well, okay, but of course that's grounded in the Paris Convention, but does it really say that in the TRIPS agreement? It incorporates the Paris Convention, but it doesn't say it directly. Now I'm going to get to you something even more complicated. In WTO law, which is very unusual, we have this idea called non-violation, nullification, or impairment complaints. That is a mouthful. A non-violation, nullification, or impairment complaint. I will use a shorthand, I will call it a non-violation complaint. Well, what does that mean? Well, you have two types of complaints you can bring at the WTO. One of them says you're violating the terms of the agreement. You need to stop, right? It's wrong, you need to stop, you need to change your rule. That's a violation complaint. You're acting inconsistently with the legal rule. The non-violation complaint says you are not acting inconsistently with the rule, but when we entered into the agreement, we had certain expectations about what the benefits were that we were going to get out of the agreement. And your behavior is depriving us of the benefits of our bargain, even though it's not specifically a violation of a rule. That's why it's called a non-violation complaint. You're not violating the rule, but you're doing something that is inconsistent with what we thought when we got into the agreement. This becomes even more complicated. Because when the TRIPS agreement was entered into, there was a question. Should we allow non-violation complaints under the TRIPS agreement? And just to make your life even more complicated and confusing, because, you know, we have a little time, so why not confuse your life? So let's go. We're getting there, don't worry. If you go all the way back to 1993, governments couldn't agree whether you should have non-violation complaints under the TRIPS agreement. It was specifically not decided. And there's a specific provision that says, and during a period of time we will negotiate about this, and when we have an agreement, we will agree that that's the result without any other formalities. So we'll decide whether or not we'll have them. Now that came into force in 1995. We've just celebrated the 30th anniversary of the TRIPS agreement. That was supposed to be settled within 5 years, and it still hasn't been settled. So every time the WTO has a meeting, at the end they say, and by the way, we still haven't figured out this non-violation issue in TRIPS. So we'll just let it ride. So now if I'm China, so now the EU says, well, yes, the panel's right, there's not a specific provision that says it, but this sounds like a non-violation complaint. We thought we'd be able to enforce our patents, but we can't because of these anti-suit injunctions. That's a non-violation thing. Then then presumably it didn't come up. Really, in this case, the panel would say, yeah, but there's no agreement on non-violation, so you still don't win. So it might be that even though I think that the EU could have made a better case, as a panelist, I might have taken a different approach to the decision, I still might have come out in the same place. I realize that's very confusing. But we'll call it, it's what judges often do, right? I agree with you on the result, but I'd like to tell you that I'd explain it in a somewhat different way. Now, this has now been appealed. So this again gets into a peculiarity of the WTO. Because we no longer have the appellate body, right? That's the way the WTO worked from its inception. If you lose a case, you can appeal to this thing called the appellate body. We don't have an appellate body now. So the WTO is essentially in some kind of free-floating anxiety form. But what happened is a number of countries, really championed by the EU, but China is also a party, have agreed to an arbitration process. So you're not going to the appellate body, you're going to a separate arbitration process to decide the dispute. And so now the EU has appealed this to the arbitration body. I don't know what they're going to do by definition. It's its own independent thing. I suspect they're not going to be that crazy about the panel jurisprudence, but they might very well come out the same place at the end of the day. So, that's the current thing going on at the WTO. It brings together a lot of threads of what we've been discussing, and it also raises the question of what's happening with the WTO institutionally and so forth. But that's the most recent development with respect to IP. Now, all of this raises a question which I'll go back to from a policy standpoint. Excuse me. Raises to me a broader question, which is why do we do this, right? I mean, so obviously globally we have this big issue of how companies adopt, or how technical standards are adopted, how companies are able to use them, whether they're patented. It's a bit odd that you're adopting a technical standard and saying, but one company has patented the standard that everybody is going to be using. And they control that, and everybody has to negotiate a license with them to use that technology, because we're not telling you what the licensing terms are. My suggestion, which presumably is self-evident, is that there's got to be a better way of doing this, right? It should be that when the technical standards body says we've decided to adopt Samsung's patent or Qualcomm's patent as our technical standard, that we're also going to say, and here's the royalty rate. If you're a developed country, it's 3%. If you're a middle-level country, it's 2%. If you're a least developed country, it's 0.5% or whatever it is. But then you should establish the rates. Otherwise, you put a great deal of dominant market position power in the hands of the company that owns the standard, the technical standards patent. So in that sense, with the Chinese companies, I think they have the right idea, right? We shouldn't be subjected to the bargaining power of the company that controls the patent because the technical standards organization has decided that they're the ones who control the technology. There should be a global licensing rate that says, and here's what the licensing rate is. If we've decided to make that the global standard, we should also say, and here's what you have to pay to use it. Why engage in this process, which is really just leading to lots and lots of trouble? Now, why that hasn't happened, that's a bit beyond me. You know, people just haven't agreed on this kind of standard. It also raises a question again, will we have more cases involving this kind of fundamental issue? Will the courts of one country, pick any country, increasingly be willing or inclined to say we're issuing an extraterritorial order? That we're not only telling you what to do in this country, we're telling you what to do in another country. Now, there is a place that we have that. In competition law, antitrust law, we tend to call it in the United States. In competition law, courts have long issued global orders in competition law. So if you're telling a company that it can't operate a global cartel, you can be telling them that what its agreement should look like outside the country where that order is being issued. So it's not as if we don't have areas where we have this kind of extraterritorial orders. We have them. And that's going to be presumably, I think, a bit more of an issue in intellectual property as we move forward. Well, we've had any number of questions come up over the course of the days of what is happening internationally, right? Is someone trying to solve this? How will it be solved? Well, we did recently have the agreement on source and origin, maybe some agreement on the high seas, but by and large, we're living in an international environment, I don't need to tell you, where countries are not particularly inclined to agree with each other on almost anything. And so when you ask me, are we going to have new international intellectual property agreements that tackle these advanced issues like AI and the new biotechnology issues and quantum computing and so forth? I'm not aware of any big push for international initiatives in this area or of any great progress being made in these areas. So I think what we as lawyers are stuck with is what we've been stuck with in any number of historical epochs, which is that private lawyers representing private clients will be trying to find the best solution for their clients, and ultimately things will work themselves out because companies want to do business and will figure out a way of doing business with each other. And with respect to kind of the whole area of the new technologies, just as a brief reminder that in a way all of this came up in the late 1970s and early 1980s. And when the internet first became a thing, and everybody said, well, we're not going to have intellectual property law anymore because we've got this thing called the internet and everything's digital and people can just copy things that are digital, so how's any of this going to survive in this environment? Strangely enough, it did. So my guess is that even though we're in a new wave, is it a more powerful wave than the original internet? Well, maybe yes. I mean, AI is an extraordinarily powerful wave. It's going to change everything we do. But will the legal system, international legal system, adapt? I imagine it will because there's really no alternative. So with that, I guess just the final point again. The major thing though, well, not the thing, is this is fine for Huawei and Lenovo and you know, Baidu and Google and Microsoft and you know, OpenAI and all these guys with, you know, hundreds of billions of dollars, even talking about trillions of dollars to invest and we're making this all happen. But if you're a small company and you happen to not have a few $100 billion, this becomes a very difficult field to be playing on when it's dominated by such large actors and such a concentration of technological power. And so that's one of the big things we'll be confronting as we move forward. So with that, I think I'll consider that kind of the formal part of my saying stuff, which I realize is some form of torture, but it's a mild form of torture depending on the way torture goes. So open discussion. Well, you mentioned an anti-suit injunction. You also have the possibility of that. I didn't get into that, right? So you have the anti-suit injunction. Then you can go to the court, say in Germany, and say, well, they've issued an anti-suit injunction. We want you to issue an anti-suit injunction so that we will fine them for continuing that process in China if they're going to fine us if we continue our process here. But perhaps that is theoretically possible. Companies are seeking anti-suit injunctions. But yes, EU courts, the UK courts, the United States courts, if recently the Federal Circuit Court of Appeals of the United States issued a decision about anti-suit injunctions. It effectively allowed an anti-suit injunction issued by a Latin American court to remain because it said it didn't have a particular basis for overturning it in that case, not a close enough nexus. So we'll have more decisions about this. But the answer to your question, if the question is, do other courts issue anti-suit injunctions, the answer is yes. And if you look at the decision by the WTO panel, they list all of the countries where anti-suit injunctions have been issued. But unless someone wants to make a general public announcement or some such, I guess we can conclude the proceedings. What do you think?